the first thing to look at is the requirements for a valid contract, and those are four. You need to have offer, you need to have an acceptance, consideration, and finally, intention to create legal relations. Well, an offer can be defined as a proposition put by one person to another, together with an indication of willingness to be bound. That offer may be made in writing, or it may be by conduct, or it may be spoken. And it may be to one person or to a group of people. But that is, broadly speaking, what an offer is, and then that must be supported by acceptance, which is the second ingredient. Well, to work out what an offer is, we need to look at and see what it is by comparison with other things, or in other words, we must look to see what it's not. The first thing is that an offer is different from an invitation to treat. It must be distinguished from an invitation to treat. If one accepts an invitation to treat, one has accepted nothing effectively, and therefore there cannot be a valid contract. The importance of the distinction between the two is that if an offer is made and accepted, the offeror, the person making the offer, is bound. On the other hand, if what the person saying, the offeror, says does not amount to an offer, the other person cannot create a contract by agreeing to it. So the first thing to contrast an offer with is a tender. Now, a tender, which is a type of invitation to treat, is the invitation to submit a price for supplying particular goods or services. But the person who puts in the tender isn't making an offer. They're merely indicating the terms on which they're prepared to contract, and that would not amount to an offer. In the same way, the display of goods for sale will not necessarily amount to an offer. In this context, the case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists comes into play. It involved a criminal or possibility of a criminal conviction under relevant legislation relating to pharmacy and poisons, but that isn't the point in question here. The question was when the sale was made. What happened was that a customer would go into the shop and select an article from the shelf, put it in a wire basket, and go up to the cash desk and pay for it. If the sale took place at the cash desk, then there was not a problem because of the registered pharmacist standing at the cash desk, and they could supervise the sale of a medicine. If the sale took place when the customer picked up the article, then Boots were going to be in breach of the law. The Court of Appeal held that the sale took place at the cash desk. The display of articles on the shelf was not an offer, merely an invitation to treat. And the offer was made by the customer taking the article to the cash desk, and that offer could be, but need not be, accepted by Boots at the cash desk. The next point to consider is when the offer can be said to have been terminated. Well, the first point to note with the termination of an offer is what happens if a counter-offer is made. If I offer someone, a potential employee, a job at, say, £25,000 a year, and that person says, no, I won't accept £25,000 a year, I will accept £27,500 a year, for example. The effect of that will be that the offer made by me to the potential employee will be terminated by the counter-offer made by them, and effectively what they have done is made an offer themselves, which then I, as the original offeror, person making the offer, must accept or reject. But at that point, it is up to me whether I accept it. So we can't say that if the person's made a counteroffer, that has brought a contract into play. The other question to consider in relation to termination of the offer is revocation of the offer. The basic rule is that an offer can be revoked at any time before it is accepted. Revocation, to be effective, must be communicated to the offeree. So if I'm making an offer to you, and I decide to revoke it, I must communicate it to you before you accept it. But unlike an acceptance, the revocation needn't be communicated by the party himself. It's sufficient if the offeree learns from a third party that the offer has been revoked. An example in point here is the case of Dickinson and Dodds. In that case, Dodds offered to sell a house to Dickinson for £800, and he stated that the offer was to be left over until Friday, June the 12th, 9 a.m. On Thursday, June the 11th, Dodds sold the house to someone else, and that same evening Dickinson was told of the sale by someone else too, a man called Berry. Before 9 o'clock on June the 12th, Dickinson handed to Dodds a letter of acceptance. The Court of Appeal said that there was no acceptance. Dodds' offer had been withdrawn before acceptance. The revocation must actually be communicated to the offeree. This is so even though the post is used as the channel of communication. The rule that an acceptance by post takes effect from the moment of posting does not apply to a revocation of an offer. In some cases, the offeror, the person making the offer, promises to keep the offer open for a stated period of time. That would be called a firm offer. And then the question arises as to whether the firm offer may be revoked before the expiry of the stated period.